Right, hello. Very good evening to the many of you joining us remotely, and also good evening to the people who are here with us in chambers. My name is Tom Weeks KC. In a departure from the published programme, I'm delighted to be chairing this landmark Chambers quarter-day seminar. It is a departure from the published programme because David Holland, QKC, who was supposed to be chairing this evening, is feeling under the weather and is therefore taking it easy at home. For those of you joining us remotely, a few points. First of all, your microphones are automatically muted. There will be a time for questions at the end of the seminar. So if any time question occurs to you, you can, if you wish, submit the question in the Q&A section at the top or bottom of your screen. And finally, if you lose connection, we suggest that you rejoin by clicking again on the original link. Now, the subject of today's seminar is that most powerful instrument of equity, the trust. Our three speakers today join Chambers by making a short journey down Chancery Lane from Chambers in Lincoln's Inn, from which they practiced for several years, and in fact, as did I. And without further ado, if I could introduce our first speaker, who is David Nicholls. He joined us. He's our longest standing member of Chambers of the speakers. He joined us, I think, about 7 years ago. This year's edition of Legal 500, which I think was published yesterday, says that David has an impressive ability to grasp the legal issues. This was demonstrated by David only last week at a trial listed for 3 days in Cardiff. The barrister who had been instructed dropped out of the case at only 3 days before the trial, and I should add a barrister from another Chambers. David took up the reins undaunted by the immense 18-volume trial bundle, and having seen off the opposition in just over a day, as we see, returned to Chambers victorious, and is therefore able now to talk to us about resulting trusts.
Tom, thanks for that introduction. And as you said at the beginning, that most powerful tool of equity, trust. I remember learning law hundreds of years ago now, being told that the trust was the sole unique contribution of English law, which is really food for thought. Good evening, everybody. It's very good to see you who are here in the room today, and good evening to everybody online. I'm going to be talking about resulting trusts in their residential and commercial contexts. And I've asked the question whether they are dead or alive. Is there a tendency? I think there is a tendency to overlook and perhaps disregard resulting trusts, particularly in the residential context. Is the resulting trust the body on the in the mortuary, or is it springing to new life? Now, in this white patch here, I tried several times to have a picture of Baroness Hale, and for some reason, she just wouldn't stay on my slide. She kept disappearing. And maybe that's a sign. Maybe she didn't want to be particularly mentioned. But I attribute, perhaps not the blame, but in my respectful submission, the cause of this tendency. I put, I say she's responsible in a very polite fashion, and perhaps Lord Walker as well. Let's put him in the frame as well. Now, why do I say that? Well, it all comes from the Stack and Dowden case, which you will remember from 2007. This was a case about an unmarried couple who bought a house in joint names. There's no declaration of trust. They somehow kept their finances entirely separate, despite being together for 40 years and having 4 children. I'm not sure how they did that. And the case is noteworthy because of the reminder that the starting point in any analysis is that the beneficial interests follow the legal interests. So joint ownership means 50-50 share as the starting point. But it's also significant as the starting point for the shift in focus from resulting trust to constructive trust. And you'll see there what Lady Hale had to say. The law has indeed moved on. So moving on from that litany of cases going back to the 1970s, petted and petted, kissing and kissing, where resulting trusts were much more in focus. The law's moved on in response to changing social and economic conditions. The search is to ascertain the parties' shared intention, actual and further imputed, with respect to the property in the light of their whole course of conduct in relation to it. And Lord Walker, as I've mentioned already, he said something similar in a case about beneficial ownership of a matrimonial home or quasi-matrimonial home. The resulting trust should not, in my opinion, operate as a legal presumption. And it comes up again a few years later in Jones and Kernet, again, a case about a jointly owned property, this time by husband and wife, not just cohabitees, but no express declaration of trust. In that case, the wife contended she owned 100% of the property. And this was a joint opinion by Lady Hale and Lord Walker. And they said the assumptions as human motivation led the courts to impute particular intentions by way of the resulting trust are not appropriate for the assessment of beneficial interest in a family home. And I think it's comments like that have tended to push practitioners away from thinking too much about resulting trust, now the very much the poor relation. So in terms of the time available to me, I'm going to talk about, explain, remind you what is a resulting trust, and then talk about how it is in fact alive and kicking in the domestic context and how it's alive and kicking in the commercial context. I'm going to focus on a very specific commercial scenario, and I'll conclude with a reminder of some of the advantages of the resulting trust. So what is a resulting trust? Well, there you can see it on the slide in formula graphic form. The classic definition of a resulting trust can be found in a number of cases. In the House of Lords, the principles were explained by Lord Brown Wilkinson in the Westdeutsche case. He said where A makes a voluntary payment to B or pays, wholly or in part, for the purchase of property which is vested in B alone or in the joint names of A and B, there is a presumption that A did not intend to make a gift to B. The money or property is held on trust for A, if he is the sole provider of the money, or in the case of joint purchase by A and B in shares proportionate to their contributions. So the voluntary payment by A to B, who acquires the property in his own name, that results back to A. But it is a presumption. So the trust operates by operation of law. It gives effect to the presumption that A did not intend to take the property beneficially, but that presumption is capable of being rebutted. It can be rebutted by proof that A did in fact intend B to take the property as beneficial owner. It could have been a gift. It can be rebutted by direct evidence. It can also be rebutted by the presumption of advancement, which may explain why the payment was made. That concept is a bit out of fashion these days. It used to apply to family members where B was legally dependent on A, so that A had a moral duty to support or advance B, such as a father, child, husband to wife, and so on. Now, a brief example of one way in which a resulting trust can still operate in the residential context is the case of Lasker and Lasker from 2008. This concerned a flat owned by a mother and a daughter, but it was an investment property. And therefore, it wasn't really in that strict domestic consumer context that Lady Hale was concerned about. And in that case, a resulting trust analysis was applied. I just want to talk about briefly a case of mine in the residential context, which was the case of Mills. And this was a case about a property in Southend. And you can see a picture of sunny Southend here. It wasn't quite like that when I was there. A residential property owned by two brothers, an express declaration of trust in the usual form on the form TR1, the transferees are to hold the property on trust for themselves as tenants in common and equal shares. One brother was made bankrupt, and so the trustee in the usual way sought to realize his interest in the property. Now, there's a but here. Mum and dad were in existence, And look, they lived at the property. That was their home. And more to the point, they actually paid the purchase price. And they didn't just pay the purchase price, they actually paid the mortgage. And so they claimed the whole beneficial interest based on a resulting trust. Now, given that the purchase price was paid by mum and dad to their sons, the presumption of advancement had to be rebutted, because otherwise that would presume that the parents intended to make a gift to their children. And that was rebutted, because in this case, mum and dad were only able to pay the purchase price by selling their existing home. And it was considered unlikely that they would have voluntarily made themselves homes in order to make a gift to their sons. And the outcome was that there was a resulting trust in favour of mum and dad. It was limited to a beneficial life interest, and that's because the judge found on the evidence that the understanding of all the parties had been that mum and dad should have a right to live in the property of their life, rather than being concerned about what would happen to the property after their death. And pausing here just as a footnote, it's interesting that the judge refused to make an order for possession sale, even one to take effect on the death of the survivor of mum and dad. He said the trustee in bankruptcy would have to reapply back to court after the death of the survivor. The trustee in bankruptcy ran an argument that because of the express declaration of trust by the two sons, which you'll remember from a couple of slides ago, the trustee said, well, the claim should fail because of that express declaration of trust. And that argument failed, but it was based on well-known comments in the case law, starting, I think, with Goodman and Gallant, but it's actually right back to the 19th century. But in Goodman and Gallant, it was said, if, however, the relevant conveyance contains an express declaration of trust, which comprehensively declares the beneficial interest in the property or its proceeds of sale, there is no room for the application of the doctrine of resulting, implied, or constructive trusts unless and until the conveyance is set aside or rectified. Until that event, the declaration speaks for itself. And again, in Stack and Dowden, Lady Hale again said something similar. No one now doubts that such an express declaration of trust is conclusive unless varied by subsequent agreement with proprietary estoppel. But the trustee in bankruptcy said, well, there's a declaration of trust here between the two sons. That's the end of it. That's conclusive. And that argument failed because it didn't take into account the fact that in all the cases where there's a declaration of trust have been held to be conclusive, it's conclusive between the parties. In all those cases, it was one of the parties to the declaration who was claiming a beneficial interest greater than the declaration of trust provided for. In my case, in the Mills case, mum and dad were not parties to the declaration of trust. And in fact, there's no case, as far as I'm aware in English law, where a third party has been barred from advancing a claim based on a beneficial interest by reason of a declaration of trust to which they weren't party. I mean, that manifestly would lead to injustice and be a vehicle for fraud. So that argument failed. So pausing here, I think the resulting trust is very much alive and kicking in the residential context. Don't simply ignore the concept, and I'm sure you wouldn't, but don't do it just because the case is a residential property. Don't be blinkered into thinking we can deal with constructive trusts. Of course, in the relatively narrow domestic consumer case involving a dispute between co-owners or cohabitees, then there is still scope in that narrow sphere, generally it's a constructive trust argument that will apply. But if you're slightly beyond that narrow scope of co-owners or cohabitees, then there is scope for the resulting trust analysis to apply. Moving on from the residential context to the commercial context, I want to focus in particular on this scenario. So X incorporates a company, Y Limited. X is the sole director and sole shareholder of that new company. And then the company goes and purchases property with funds provided by X. And X forgets all about the company and it gets struck off the register and is dissolved. And then the property vests in the Crown as bona vacantia. What can X do? Now, this sort of scenario, I think, was relatively common in the property boom in the noughties and beyond, because investors were trying to purchase property, often for buy-to-let purposes, and they were trying to use tax favorable corporate structures. And of course, there are a lot of big investors, but there are a lot of individual investors making one-off purchases. And often they were naive, with little experience or knowledge and a lack of understanding about their responsibilities as directors. So what are the options open to X? Well, one option is to seek restoration of the company. Now, that may not be possible if the relevant time limit has passed. What about our friend, the resulting trust? Well, given those basic principles of resulting trust that I mentioned, surely this should be straightforward. If the shareholder provides the company with the purchase monies to acquire a property, then based on that formula from Lord Brown Wilkinson, why would the property not be held by the company on resulting trust for the shareholder? Well, if you can establish a trust, then you've got a way forward. You can rely on Section 44 of the Trustee Act 1925, which gives the court power to make an order vesting land in any person where a corporate trustee has been dissolved. There is, of course, a but, a big but, and it's in bold. And it is this: there is a presumption or an inference that should be drawn. And it was set out in this case called Nightingale, Mayfair, and Meta by Mr. Justice Blackburn, who said that the proper and natural inference from the decision by an individual to purchase a property in the name of the company and provide it with the funds to do so, especially where the company is controlled by the individual, is that the company should be the beneficial as well as the legal owner of the money and then the property. So there's that presumption against a resulting trust operating in the company sphere. And something similar was said in the Stockholm finance case from 1995, and the judge was our friend, Mr. Justice Robert Walker. If a private company is sole legal owner of the house and the occupier of the house is sole legal and beneficial owner of all the company's shares, then so long as both parties remain solvent, there is no basic economic difference between the company being sole beneficial owner of the house and being a nominee for the occupying shareholder. Now, this presumption against the resulting trust is capable of being rebutted. And the case of M&M in 2013, which was a case in the context of divorce, is very helpful here in setting out how the court should approach rebutting that presumption. Now, this was a case in which the wife claimed financial relief, including an order that the husband transfer to her English properties registered in the name of companies he owned. She claimed that the husband was worth £100 million. She claimed he'd retained the beneficial interest in these properties under resulting constructive trust. So the opposite of the example I gave, it's not the shareholder in this case claiming the resulting trust, it's the wife of the shareholder. And the husband denied this. Now, the judge was very critical of the husband's conduct, saying he had no respect for regulations, he did not regard tax as an issue for him, and had no intention of paying tax in the future. One can see the judge was not very favorable to the husband. And she concluded he had used these offshore companies to place the properties beyond the wife's reach, and that he had intended, therefore, to retain the beneficial interest in those properties. And the court drew adverse inferences against the husband, partly from his failure to comply with court orders and also from his failure to give evidence. And the court said had a number of propositions for rebutting the presumption. First of all, that the search for evidence of subjective intention of a transfer or actual intention is the purpose of the court in making this assessment. It's the search for that evidence. Secondly, that there is the presumption applies in the absence of evidence of intention. And where the sole shareholder claims the beneficial interest in property owned by the company, then the burden remains on the transferee to rebut the presumption, and positive evidence of the source of funds establishes the ordinary inference that the provider of funds is the beneficial owner. Now, a couple of examples in the case law of where that presumption against the resulting trust, where the argument has not worked to overcome the presumption. One was Stockholm Finance, where there was no evidence that the shareholder, somebody called Princess Nadawi, no evidence that she did not intend the company to own the property. And back to the Nightingale case, there was unchallenged evidence that the company should own the beneficial interest. The whole point of setting the company up in that case was for tax purposes. That would only work if the company actually beneficially owned the property. But cases where the presumption against resulting trusts has been rebutted include M&M, for the reasons I've mentioned. Another case, United Overseas Bank from 1999, where the court concluded there was never any intention to transfer the beneficial interest to the company. And the judge concluded the directors and shareholders did not exercise any independent judgment at all and just did what they were told by the solicitors in question. So that was not really a genuine arrangement. And finally, I just want to end with some other examples to indicate the sort of things that tend to persuade the court, because these sorts of applications are not always straightforward. Mr. Greer, I think, was a retired fireman from memory. He had set up a company many, many years ago that had been dissolved long after the period of restoration passed. And somewhat remarkably, in the bundle of papers, there was not the actual declaration of trust, but there was evidence that it had been entered into in terms of the correspondence between him and his solicitors. So there was clear evidence of actual intention, and that was highly persuasive in enabling the resulting trust analysis to take place. Another case I was involved in involved somebody called Putney. Now, this was slightly different because he was never the director or the shareholder, but he had provided all the purchase monies. And again, he was able to establish a resulting trust because the court drew adverse inferences, and you'll remember that factor from the M&M case. The court drew those adverse inferences from the absence of a response from the director and shareholder. They just simply did not engage. Whether there was some underlying fraud, I don't know. And Sheikh was another case, a classic case of a property investor who was completely out of his depth, and indeed the property had even been sold by the mortgagee. The evidence showed the company was only used because his sons had told him that's what he should do, and he thought it would help him get a mortgage. He exercised no independent judgment at all. He had no understanding of his obligations as a director. The company was struck off within 18 months of purchase. I mean, he just did nothing. But what was persuasive in the court concluding there was a resulting trust was the fact not just that he paid the purchase price, but that he paid the mortgage, and he carried on paying the mortgage for many years after the date of dissolution. And in that case, the court was persuaded by a decision called Tahir and Faizi, and that was a case where the court concluded that if there was an agreement at the time of purchase of a property, the party would be responsible for mortgage installments on terms that they would have a commensurate beneficial interest, or in circumstances from which such an intention would be inferred, such payments would confer a beneficial interest on the payer. And so I can see our chairman twitching. I've overrun my time. We've had enough, I'm sure, resulting trusts, but they are alive and well, and they do, applied properly, allow for a simple, clear analysis, straightforward outcome, no complex issues about quantification, and very useful in the company context, as I've described. Thank you for listening.
Thank you, David. Next up is Evie Barden. For some time, we at Landmark Chambers were aware of Evie's reputation as one of the best up-and-coming juniors in the property bar. And so we were delighted when Evie joined us from Enterprise Chambers a couple of years ago. This year's Legal 500 says that Evie has a tremendous ability to simplify and streamline the most complicated and unwieldy of issues. So let's put that to the test now by inviting Evie to speak to us about constructive trust and unjust enrichment.
Thank you, Tom. I hope I can live up to that. Most people attending today will be very comfortable, I suppose, with the principles behind common intention constructive trusts. But what about constructive or possibly resulting trusts, which arise where a property has been transferred to another person, pursuant to a void contract or mistakenly? As you can see on the slide, the second question I've asked is, can the transferor get the property transferred back to them? And on what basis could the transferor get that relief? I'm going to talk to you about a case called Fatal and Fatal, which was heard in March this year and decided by Deputy Master Hanson. In It's the most recent and authoritative decision on proprietary remedies where a claimant has a claim in unjust enrichment and would be entitled to seek a personal remedy. That case is also very helpful for the principle behind common intention constructive trusts, and is an interesting read for that reason also, especially where one is looking at how to establish a trust on that basis by inferring intentions from all the circumstances, particularly contributions to purchase price and capital investments. The facts of Fatal and Fatal were that it was a dispute between two brothers, William, who was the claimant, and the elder brother, aged 82 at the time of trial, and his younger brother, Elias, aged 79. It was about a property in Nottingham Terrace, a 4-bedroom penthouse flat opposite Regent's Park. And as one can guess, it was quite valuable. There was no formal valuation evidence at trial, but in 2013, a valuation had put it at 2.4 million, and there were indications that it was between £4 and £5 million at the time of trial. As one can also guess, the proceedings were shrouded in quite a lot of acrimony between the parties, but that had not always been the case. William and Elias had for some time had a very strong relationship and had, on the judge's findings, mutual respect and trust for some time. They had lived together for a number of years and had a number of business interests, which from 1962 they'd operated very successfully. And in short, they were for a long time very wealthy and very close with one another. In 1972, the flat had been purchased for £59,000 in William's sole name, made up of a deposit paid by him and a loan to William secured by a mortgage. In 1974, following refurbishment works, the brothers moved into the flat and they lived there together until 1990. Before that, Elias got married, and then shortly afterwards, the marriage was annulled. And in that same year, the brother's father died. And William had sought to make quite a lot of this for a reason I'll explain in a minute, although the judge said it, in fact, had very little significance. But the reason William made a lot of it was that in 1990, he got married and moved out of the flat with his wife. And at that point, Elias continued to occupy it. There was then a discussion, and initially this was a point of contention between the parties, but latterly Elias agreed it. A discussion in 1990 or 1991 between them, where William made an offer to Elias that he could purchase the flat from William for around £400,000, which everyone agreed was to be market value at that point in time. Critically, that never crystallized into any writing. So there was no agreement that complied with the requirements of Section 2 of the Law of Property Miscellaneous Provisions Act. Until 1999, Elias lived in the flat, and thereafter he got married again, and he moved out of the flat into another property. The flat was then rented out by a company that both brothers had interests in, but Elias retained all of the rental income. Basically, from 1990 onwards, everyone behaved as if Elias was the sole beneficial owner, notwithstanding that William was the sole legal owner. Then, in around 2012, the brothers and their many legal and financial advisors started talking about how Elias could reduce his tax burden, which led to the parties discussing Elias being transferred the property by William. That correspondence suggested that everyone thought that Elias had, in fact, bought the property from William, and as a result, a TR1 was drafted by Collier Bristow. Slightly oddly, that TR1 stated that William was transferring the property to Elias for consideration, and that he had provided the entirety of the original purchase monies, which everyone at trial accepted not the case, either because on William's case, the TR1 was executed because he assumed that consideration had in fact been provided to him, or on Elias's case, because he had, in fact, provided it. There was then a lull, but it all got picked back up in 2014 and the TR1 was executed. And it was in the form that said that Elias had provided the consideration for the original transfer. After the transfer, surprise, surprise, the brothers fell out. And William started to investigate whether, in fact, he received any money for the transfer. Finding out that he hadn't, he approached William and said, Elias, and said, "Where's my money?" And it was in around April 2018 when the judge found that Elias realised he'd never paid William for the flat. I've skipped ahead, but relevantly, the findings were that in 1972, the property was solely and legally beneficially owned by William, and Elias had made no contributions either to the initial purchase price or subsequently to its refurbishment. So no common intention constructive trust arose at that point. Interestingly, there was some discussion of a case called O'Neill and Holland, a 2022 Court of Appeal case that says you have to have detriment in order to establish a common intention constructive trust. And the reason I say that's interesting is that that case is going to be re-examined soon by the Court of Appeal in the case of sole acquisition, common intention constructive trust. So watch this space, that might be a development. Another thing the judge found is that there was no consideration provided by Elias pursuant to the oral agreement that Elias could purchase the flat from William. That was a pretty big issue at trial because Elias argued it was for William to show that he had not paid and that the funds must have come from one of the many corporate vehicles or trusts that the brothers had. And because William was the patriarch of the family, only he would have had access to that information. That was roundly rejected, partly because of the documentary evidence that did exist, a conversation between Elias and one of the brother's nephews, in which Elias told the nephew he was prepared to pay off his financial agreements. And because of the very paltry efforts that the solicitors and Elias had made to attempt to obtain any documentary evidence. So necessarily the court had to find that from 1990, 1991, William remained sole beneficial owner of the property and no common intention or resulting trust arose. So then to the transfer in 2014, why had that been done? Was William mistaken about having been paid for the property? Well, any listener might well ask, why would one transfer a valuable property without checking that you've received the consideration you've been promised? Fortunately for William, his excessive wealth meant that the judge found that he was far from the ordinary man on the street, and it was indeed plausible that £400,000 was not a significant sum to him in terms of his personal and business wealth. Most pertinently, this finding really seems to have been driven by Elias's pleading that neither he nor William had intended that this would be a gift and that Elias had provided consideration. The judge said the likelihood was that if Elias had not provided consideration, then William must have been executing the TR1 in the mistaken belief that his proposal had been accepted and consideration had indeed been provided. The judge then found, as I said earlier, that Elias became aware of the mistake in April 2018. So what then, as a matter of law, as it says on the screen, in general, where a person transfers an asset to a third party by mistake or pursuant to a void contract, the intended transaction can be unwound and both sides put in the position they were in before the deal was entered into. That is in the nature of a restitutionary claim, the defendant having been unjustly enriched at the claimant's expense. So in the first instance, William's relief would be personal in restitution. He would be put into the position he had been in prior to the deal, subject to any defences that would have to obviously be pleaded. But can a claimant in such a position get a proprietary remedy? Now, that has been extremely controversial, but one might look back to the Westdeutsche case that David mentioned earlier for the starting point for an idea on this. Lord Brown Wilkinson said in that case, although the mere receipt of monies in ignorance of the mistake gives rise to no trust, the retention of the monies after the recipient bank learned of the mistake may well have given rise to a constructive trust, i.e. the knowledge of the defendant will determine whether the defendant's conscience is affected such that the claimant can acquire a proprietary interest in the asset mistakenly transferred. This has been occasionally referred to as the remedial constructive trust, and I think it's generally not been met with approval in this jurisdiction. But fast forward 24 years to Ali and Dink, a High Court case from 2020, where Sarah Worthington Casey, sitting as a deputy High Court judge, took up this idea. In that case, the claimant had been the registered proprietor of some freehold properties, which were transferred to the first defendant for nil consideration. And after the transfer, the claimant continued to live in one of those properties rent-free. The claimant said the transfer was subject to an oral agreement. And the other party said that it was a gift. The court, finding that it was not intended to be a gift, but in fact subject to an earlier oral agreement, looked at how a trust might arise in those circumstances. There being no binding agreement which complied with Section 2 of the Law of Property Miscellaneous Provisions 1989 Act, the parties would have been obliged to make restitution and counter restitution. And the judge said, once the defendant was on notice that restitution was warranted, the interest held in the properties was held on constructive trust for the claimant. Referring back to that passage that from Lord Brown Wilkinson in West Deutsche, Sarah Worthington said, in short, the personal obligation to make restitution of the particular assets received under the void contract was rendered proprietary once the defendant was on notice that the assets were not to be treated as the recipient's own and restitution was in order. So the constructive trust arises from the moment that the person who receives the asset knows that the asset is not to be treated as their own. Ali and Dink was then appealed to the Court of Appeal, albeit on a different point, and was indeed unsuccessful. In Fatal, Deputy Master Hanson applied the dicta in Ali and Dink to find that a constructive trust had arisen. All that was really said against it was that it was pretty sketchy authority, and on that basis, and on the basis that it had been affirmed in the Court of Appeal, the Deputy Master found that a constructive trust on that basis would arise. The court then also went on to think about whether there was another way of formulating the relief that was sought, the return of the property. First, the first way was by the jurisdiction arising in Pitt and Holt, which is that the court can rescind a gift where a donor has acted under a mistake of a sufficiently serious character to mean that it would be unjust for the donee to retain the gift. Critically, it doesn't matter that the mistake might be due to carelessness on the part of the person gifting the asset, unless they deliberately ran the risk or have been taken to run that risk. It depends on the unconscionability, and that must be objectively evaluated, requiring a close examination of the facts about how the mistake arose and the consequences for the person making it. There's a case called Van der Merwe and Goldman where it's been subsequently applied, and that examines the difference between cases where the equitable rules in Pitt and Holt apply and those which do not. And that distinction turns principally on where there has been consideration provided for the benefit conferred by the transaction. And the judge in Fatal and Fatal, holding that Elias hadn't provided any consideration for the transfer, found that the jurisdiction would arise. The other way in which the judge found that William would be entitled to return of the property was under a resulting trust on the basis that it hadn't been intended as a gift. So on all fronts, William was successful. Just some further things to think about that come out of the judgment or arise generally from this jurisdiction. The first thing is, on what date would the constructive trust arise? Now, that can be quite important if there are third-party interests that have arisen since the date of transfer. Not an issue in the Fatal case, but can often arise, and result in trust that arise from the date of the transfer, whereas the constructive trust, the alien dink constructive trust, would be from the date that the person is fixed with the knowledge that it was a mistake or that they weren't entitled to retain it. No analysis in any of the cases of the type of knowledge. I'm sure the Barden types 1 and 2 actual knowledge, willfully shutting one's eyes to the obvious, would be sufficient. But what about constructive knowledge? So that's something that might be explored in further cases. And the other thing that it can be relevant to is equitable accounting. In Fatal, William claimed that Elias had to pay him the rental income that had been retained by him. That was time barred pre-2014. But the next question was he entitled to it from 2018 or an earlier date, 2018 being the date that Elias was fixed with knowledge. Got around that because of personal remedies, because a personal claim in unjust enrichment arises from the date of receipt rather than the date of mistake. That's Benedetti and Suarez, but it might be irrelevant in other cases for the purposes of accounting. And then lastly, there was a faint hint by the defendant of a change of position defence in relation to the equitable account, but restitutionary defences, whether for a personal remedy or proprietary, always have to be pleaded and proved, and no pleading in that case. So a very valuable remedy, reminder of the importance of pleading your defences in a claim, in any claim where unjust enrichment is the basis. And I'll hand over now to James.
Great, thank you, Evie. Our final speaker is James Hanham. James has a formidable reputation as a property junior, so we were delighted when he joined us from Maitland Chambers earlier this year. This year's Legal 500 says that James is a superb advocate. He's also a superb speaker, as you'll see when he talks to us about joint ventures. And in doing so, no doubt, James will explain what a talk about joint ventures is doing in a seminar about trusts.
Tom, thank you very much. Joint ventures, a question of trust, question mark. I'm going to look this evening at a number of questions which touch upon that initial question. The first is what can be made as between what I'm going to describe as written agreement cases and oral agreement cases. In the context of oral agreement cases, where are we with what's called the Pallant-Morgan equity? What role does the common intention constructive trust, the CICT, have to play any longer in the Pallant-Morgan equity? The significance of what the Court of Appeal had to say about this area and generated developments in Liddell in 2018. Some reflections upon the question of unconscionability, and also in that context, the question of proprietary estoppel. And then I'm going to consider a recent case called Dixon and Willen, a High Court decision of Mr. Justice Corson from August. And then finally, I'm going to look at the question of written agreement cases and the significance of fiduciary duties. A joint venture, as I'm sure you all know, is a business arrangement in which two or more parties agree to pool their resources for accomplishing a specific task. That task can be a new project or any other business activity. The JV can be structured as a separate business entity or simply grow out of a contract between the parties. Typically, it's temporary and it comes to an end once the object of the JV has been achieved. The concept of a JV is not wholly unlike some of the circumstances that we've been lucky enough to have expanded upon and explained with such erudition by David and Evie. At its heart, the JV concerns a relationship, the operation of which is susceptible to nuanced control by the court. Conversely, it might be said, and rather unromantically, that an unmarried and cohabiting couple embark on a form of joint venture. In either case, equitable principles have been developed to lessen the perceived inequalities created by the strictures of the common law. Sorry. Get that right. Like the proverbial elephant, the courts have found the JV easier to recognise than describe. The term JV is a business term which, quotes, does not have a precise legal meaning, as was said in BBC Worldwide. Indeed, it's been said that it's not even a term of art in business, as was said in Ross River. JVs arise in several contexts and in a number of different ways. Often, although not always, as we shall see, the parties enter into a JV agreement individually or through a corporate SVP or LLP. Usually, the property, the subject matter of a scheme of development, will be owned by a company in which the joint venturers will have an interest. So not infrequently, the parties enter a shareholders agreement in relation to the shareholding in a corporate vehicle. In cases where such agreements exist, which I'll call written agreement cases, the disagreements tend to be about how the parties conduct the relationship between them when it comes to the operation of the object of the joint venture. Separately, notwithstanding that a joint enterprise involves valuable assets, joint venturers may, and have done, as the cases show, embark on a project without an agreement having ever been concluded in writing, which I'll call the oral agreement cases. The question I'm concerned with today is what principles are being relied upon in these instances. To answer Tom's question, this topic belongs in the seminar on trusts because in recent years, in the context particularly of no agreement cases, the courts have debated the relevance of the common intention constructive trust, invoked, as I said in my introduction, in the context of what's called the Pallant and Morgan equity. In the context of written agreement cases, the debate has revolved around the existence and nature of fiduciary duties that joint venturers might owe to each other. Further, in some oral agreement cases, judges have sought to explain their relationship as having at its heart a fiduciary character. That's the case of Farrer and Miller. So where it arises, it's said that a Pallant and Morgan equity relates to a specific property that is not at first owned by either of the two parties that are parties to the case, A or B. A and B form a common intention that A will acquire the property and that if A does so, B will obtain some interest in it. The common intention will not be recorded in writing. Pallant itself, which was a case decided as long ago as 1952, concerned an oral agreement to which the claimant agreed orally with the defendant not to bid for a property at auction, in return for which the defendant would, if successful, transfer part of the beneficial interest to the claimant. The court determined that there was an element of fraud in the defendant's conduct in refusing to transfer the property after having bid successfully at auction for it. And the element of fraud was relying upon the lack of formal legal formality. So the effect of the equity is that A becomes bound by a constructive trust to prevent him from benefiting by his unconscionable breach of the unwritten agreement. So A will hold the property on trust for himself and B jointly. So the remedy is one of declaration of beneficial interest, the shares in which will depend upon the evidence. The so-called locus classicus of the Pallant and Morgan equity was set out in Banner, Holmes and Luff by Lord Justice Chadwick. And the elements of the Pallant and Morgan equity are these. First of all, the parties' agreement must precede the acquisition of the land. Secondly, the agreement need not be, self-evidently won't be, contractually enforceable. Thirdly, the agreement, the oral agreement, must contemplate that B would obtain some interest in the land. A must have relied on the agreement by conferring an advantage on B in relation to the acquisition, or have suffered a detriment to A's own ability to acquire in equal terms. And finally, and importantly, it would be inequitable to ignore the agreement. In generator development, the case from 2018, which I mentioned at the outset, the Court of Appeal re-examined the nature of the Pallant and Morgan equity and whether it did in fact rest on common intention constructive trust principles, or, as Lord Justice Etherton had persuasively but unsuccessfully argued as a minority in Crosco No. 4 Limited versus Jonah Limited, It was an equity arising out of a breach of fiduciary duty. Although a debate as to whether the obligations as between A and B arise by reason of a trust or by reason in context of fiduciary duties might seem, and probably is, a bit dry, the Court of Appeal's conclusion in Generator that the Pallant and Morgan equity was based upon CICT principles applied a hard brake to the momentum of this principle. That brake appeared to rest on the simple but well-established principle of the use of the subject contract rubric in negotiations. In commercial cases, parties are almost certainly going to be acting through lawyers on an arm's length basis and have the advice of lawyers who know how to conclude a binding contract and avoid entering into one until their client is finally ready to do so. When negotiations were formally or informally subject to contract, it was difficult to see, the Court of Appeal concluded in Generator developments, that the parties could have had a common intention to otherwise bind themselves. There was nothing upon which the CICT could bite. Further, although the parties may reach an informal understanding of their agreement, they know it is going to be subject to a later formal contract. In that knowledge, neither party can claim to have been treated unconscionably when there's an expectation that a formal contract subsequently would be signed. Some commentators have sought to characterize Generator developments as having killed off the CICT as simply having no relevance in the commercial context. However, as it seems to me, the better view is that in many, but by no means all, commercial contexts, the parties will know that they are not legally bound until a formal contract is concluded. The fact that the dispute emerges between two commercial entities, as opposed to in a domestic or residential context, is likely to give rise to the subject to contract issue, and whether unconscionability can exist at all. Perhaps the better way of looking at this, and the appropriate focus for the party's evidence, a point which the claimant's advisors overlooked in a recent case, and I'm going to mention in a moment, is to remember that we are concerned with equity. At its root, equity is concerned with unconscionability. That focus nicely aligns with the alternative theory of Pallant and Morgan, which is that, in fact, it rests upon a proprietary estoppel, which is often run as an alternative and additional claim in a Pallant-type case, which, as you know, also requires an element of unconscionability in establishing the principle. It's the conduct of the defendant that generates the equity, not the joint conduct of the parties in having formed a common intention. It's the very fact that the defendant has unconscionably denied an expectation reasonably created by his conduct that leads to the intervention of equity. However, in the same way, parties negotiating subject to contract are unlikely to be able to rely upon proprietary estoppel. As you'll remember, the claimant was not, in Cobham Yeoman's Row Management Limited, able to establish a proprietary estoppel because, as was said by Lord Scott, a would-be purchaser's expectation of acquiring an interest in the property in question is subject to a contingency that's entirely under the control of the other party to the negotiations. However, we ought perhaps to pause to question whether or not it's plausible to analyse the oral agreement cases as a species of proprietary estoppel at all. The familiar elements of assurance, reliance, detriment, and unconscionability, after all, all being present. My view is that it would help to simplify matters a great deal. Lord Justice Lewison said about this issue, the following in Generator development. The principles as expounded by Lord Justice Chadwick in the Banner case are firmly based on supposed congruence between the principles of proprietary and the doctrine of common intention constructive trust. But we've seen from Cobb that the House of Lords firmly denied the applicability of proprietary estoppel in a commercial case like this one, where each party knows that they are legally bound. However, it could be said that this relates primarily to the subject to contract argument, not the principles which underpin these cases. Of course, the origins of the Pallant and Morgan equity are, as we've seen, planted firmly in the concept of fraud. So it appears that as a matter of legal principle, at least, proprietary estoppel needs to be kept apart. So after Generator developments, to what extent does the Pallant equity really remain a useful concept? The answer is that it remains, in the right circumstances, a perfectly credible cause of action. In order to keep this presentation somewhat topical, We should note that one of the causes of action pursued, albeit unsuccessfully, in the recent High Court case of Dixon and Willen, as I said at the beginning, a case from August 2022, was Appellant and Morgan Equity. Briefly, the facts of the case were these. Mr. Dixon and Mr. Willen had separately been property developers, the latter operating through wholly owned corporate vehicles. Promisingly, given what I've already said, for a Appellant-type claim, negotiations for a property development JV were concluded upon a shake of hands whilst viewing one of the properties, all of which were located in Cumbria. Under the alleged JV agreement, the defendant or his companies was responsible for purchasing the relevant sites. In the end, he used his own money and or his own loan finance. The claimant, it was alleged, was responsible for sourcing and negotiating the acquisition of the sites, assisting with sourcing finance and the planning permission. The defendant was to carry out the development work through one of his companies. The claimant's claim for appellant equity in respect to 3 of the 5 sites that were subject matter of the dispute was the effect that Mr. Willen's corporate vehicles were to be treated as having acquired the sites subject to an equity in Mr. Dixon's favour. The equity was to be satisfied by the declaration of a beneficial interest, the extent of which to be determined on the evidence, the consequence of which should be the sharing of profits from the JV from the proceeds of sale. The claimant's claims, including that for appellant equity, failed on the facts, not the law. The parties had initially agreed to incorporate a limited company for the purposes of the JV. The defendant's case, which the judge accepted, was that it was always the expectation, and indeed the agreement, that Mr. Dixon would provide 50% of his own, or 100%, the case somewhat changed on this, of the funding requirements to the joint corporate vehicle. However, that vehicle was never used because it became clear that Mr. Dixon was unable to produce either his own finance or funding to the company. So the properties were registered in the name of one of Mr. Willen's corporate vehicles instead. As the judge found, the requisite common intention that Mr. Dixon would enjoy some form of ownership without contributing to the cost of acquisition was absent. The understanding was that Mr. Dixon would only be entitled to share in the profits or some other interest in the property if he made the appropriate financial contribution or procured funding. He never did it, so the equity didn't arise. So if it can be said, as it was by Lord Justice Etherton in Crossco, that written agreement joint ventures might rest upon the existence of a fiduciary duty rather than upon the principle of common intention constructive trust, is there anything to be learned from the way in which the courts have dealt with written agreement joint ventures? Immediately, one could say that we're in different territory here. Written joint venture agreements are often drawn up by experienced lawyers. Disputes concern the nature of the obligations, not whether or not a technically unenforceable agreement may nevertheless have legal effect. It might be said to constitute an impermissible blurring of the demarcation established in generated developments. Having said that, we're considering a broadly similar relational undertaking that, as was said in the case of Farrer, is at its heart a fiduciary relationship. The first point to be made about these written agreements and the concept of fiduciary duties is that a party isn't subject to a fiduciary duty because they are a fiduciary. It's because they are subject to the duties that they're called a fiduciary. A fiduciary undertakes to act for and behalf of another in circumstances that give rise to a relationship of trust and confidence. That's what was said about the issue in Bristol and West and Mothew in 1998 by Lord Millett. As the judge said in L. Hanham and Kent in 2018, fiduciary duties typically arise where one person undertakes and is entrusted with authority to manage the property or affairs of another and to make discretionary decisions on behalf of that person. The essential idea is that a person in such a position is not permitted to use their position for their own private advantage, but is required to act unselfishly in what they perceive to be the best interests of the principal. If all the above elements characterize the relationship between the parties, then fiduciary duties might well arise, the principal element of which is to be loyal to the principal. However, the fact that one party to a commercial relationship trusts the other does not predicate a fiduciary relationship. Trust does not per se lead to subordination of one party's commercial interest over the other. And that was something that was said by Dame Mrs. Justice Gloucester in the JP Morgan Chase Bank case. If it applies, the concept of loyalty, which was defined by Bristol and Weston Matthew, imports the following notions. Most importantly, perhaps, acting in good faith. Secondly, not making a profit out of the trust invested in him. Thirdly, not put the trustee mustn't put himself in a position where his duty and interest may conflict. And finally, not to act for his own benefit or for that of a third party without informed consent of the principal. The second point you made is this: the relationship created by a joint venture agreement doesn't of itself give rise to fiduciary duties, so as to be fiduciary in nature. And that was said in the fiduciary services case. Indeed, outside certain settled categories of case, for instance, self-evidently trustee and beneficiary, solicitor client, partners in partnership, company directors and principals and agents, it's been said, as it was in Hanham, that it is only an exceptional case in which fiduciary duties arise. Thirdly, however, it has been said by the High Court of Australia that the existence of a contract may be the foundation for the erection of a fiduciary relationship. In determining whether or not a fiduciary relationship exists, the cases in this area, of which there are four, Murad, 5, Ross River, Hanham and Kent, and most recently Russell and Cartwright, have tended to focus on the relevant relationship in its context and whether or not a party has particular responsibility for and has control over the furtherance of the common design. So in Murad, the claimant was wholly dependent upon the advice and recommendation of the defendant. In Ross River, the director of the defendant had control over all aspects of the management of the JV project. Conversely, the evidence in Russell and Cartwright showed that the parties throughout were only looking after their own interests. Self-evidently, perhaps, in the cases of a written agreement JV, the relationship is at the outset governed by the terms of the contract. If the parties have catered for an issue in the contract, it's unlikely to be supplemented by fiduciary duties. So, for instance, if the contract imposes obligations of good faith, the court are not going to impose them further. However, the terms of the contract may perfectly unintentionally, give rise to a relationship in which the imbalance of power operates, which is rebalanced by the imposition of fiduciary duties. A breach of those duties need not be cynical. So, for instance, in Ross River, the judge found that the payments to third parties were made in good faith, but the Court of Appeal determined they were nevertheless in breach of fiduciary duty because their effect was to jeopardize distribution of profits to the joint venturers, including the claimants. Consequently, as it seems to me, a focus on the content of the fiduciary duties might help us to understand the nuances of unconscionability. Fraud, as in Pallant, is not too difficult to recognise. However, at the margins and in its context, the analysis might benefit from returning to the now well-established elements of the conduct expected of a fiduciary. So, in conclusion, and drawing their threads together, what does the present landscape look like? There is an argument that most of these oral agreement cases are better analysed in terms of proprietary estoppel. However, that might be difficult in light of what Lord Justice Lewison said in Generator, citing Lord Scott's bright line in Cobb. In any event, it may not matter what we call it, because you can just run one with the other. But sticking with the CICT analysis for a moment, equity will not assist a joint venture party that knows or is to be taken as knowing that any agreement needs to be subject to formal confirmation. I won't be bound by negotiations previously subject to contract. Firstly, we need to think about unconscionability. And that's the key, it seems to me. Detriment incurred in relying upon the defendant's assurance on its own is not likely to be enough, but it does appear from some of the cases that too much emphasis is placed upon it, certainly when it comes to gathering evidence on behalf of a claimant. Depending on the circumstances, could it be argued that the nature of the parties' relationship in an oral agreement case might give rise to an argument about fiduciary duty and duties, not about common intention constructive trust? Even if, at a level below the Supreme Court, that argument is not open to a claimant, the content of fiduciary duties might help us understand better the contours of the concept of unconscionability for the purposes of this area. Many thanks for your attention.
Thank you, James. We now have time for questions. So either in the room or those people who've joined us remotely. Are there any questions? No. Okay, if there are no questions, I will draw the seminar to a close by, first of all, thanking speakers for their excellent talks and also inviting those people in the room to join us for a drink. Thank you.